Welcome to Trust Us, Estate Planning Wisdom, the podcast where we unravel the complexities of estates and trusts to empower you with the knowledge needed for effective estate planning.
This podcast is hosted by seasoned estates and trust attorneys, Danielle.Friedman, hfineburg, and Charles Max McCauley.
This podcast is your guide to the intricate landscapes of estate planning, including wills, trusts, and probate.
Thank you for joining us, and we hope you find the discussion informative. But remember, when it comes to legal matters, always consult with a qualified attorney regarding your specific case.
Thank you for tuning in. I wanted to review with our group, Danielle, Max, and myself, Herb, a question that I read in an article recently, which dealt with sharing the wealth. The article reads as follows. I have 2 sons from my first marriage and a third son from a later relationship. The boys are very close. I love them equally, and I want to create an estate plan that's fair to all of them. My current will divides my estate into 3 equal shares for each of the boys. But the mother of my 2 older sons is financially comfortable, and they stand to receive a decent inheritance from her. My youngest son's mother is not well off, and he will probably receive little from her estate. Here's the question. Should I revise my will to increase the amount that I leave my youngest son to balance out what the older boys will receive in total from their mother and me? I worry that my older sons will be hurt if I leave more to my youngest son. And the letter is from Dad. What do you think, Danielle?
Oh, I have so many thoughts. You know the old adage about assuming things. I think this falls right into that category. One, Dad here is making a lot of assumptions. He's assuming that the older son's mother is going to leave them a sizable inheritance. We don't know if Mom is remarried. Maybe she has stepkids that she's going to leave money to. He's assuming that his youngest child may not receive much from his mother. I just think this is ripe for conflict unless he leaves everything in equal shares to his children. Without doing that, you're just setting up a family to have conflict after you're gone.
Max, what could be the problem if you leave your estate equally to all 3 of your sons?
I think that is the safest solution, as Danielle said, to avoid future conflict among the children. But I'm not unsympathetic to the reasoning of the father, where he wants to account for either their current wealth, which is an issue we see at times, or their future wealth, meaning how the 3 boys would inherit from Mom as well as from Dad. But I think it's important for the father to solve the problems now, meaning leave it in 3 equal shares. And Danielle has some techniques that she can share about what happens if the boys don't actually need it or don't want the money. But I think if you kick the problem down the road through a variety of estate planning tools, such as pot trust, and again, Danielle will fill us in on that, or otherwise, you risk the children fighting or a trustee or the executor, executrix being left with some very difficult decisions that would have been better off made by Dad. So I think the best way to go is to split it 3 ways equally, and that tends to be our advice. But again, I'm not unsympathetic to the different levels of economic wealth.
And if the older children are of such means where they really don't need Dad's inheritance, and there are a couple different options. One, Dad could still leave them the money and they could disclaim their interests in the inheritance. And that means that within 9 months of Dad's death, they have the right to say, no, I don't want this. And it will pass to the other beneficiaries. It really depends on what the estate planning documents say, but the children would likely get it, or because the children are treated as predeceasing Dad. Maybe it would go to the grandchildren. We don't know. Another option, like Max alluded to, is leave it in a pot trust. And a pot trust is really, rather than having 3 separate shares for the kids, everything would be commingled into one pot for all three children. And then if one child has more needs than the other child, more resources can be expended for the child with greater needs. I think that defers the decision that dad should be making and puts the decision in the hands of a trustee and makes their life more difficult and complex. I don't know anyone who really likes administering pot trusts because you really have to make value judgments.
Does that create, in my mind, that sort of creates an issue between the children?
Yeah.
Will they all be applying for money from the trustee for their particular needs? And one's needs might be more foundational, like shelter, rent. Another one might be, I need a new car, or we want to fix up our house, or something like that. So the pot trust sounds like it creates tension between the children, and the parent has said, not my problem. I'm going to make it your problem. But in the end, parents really want their kids to get along once they left this earth. And those are great relationships between siblings.
Yeah. We always tell our clients that the most valuable thing that you're doing with your estate plan is leaving family harmony and ensuring that everyone gets along, or hoping that everyone gets along, at least setting them up for success to do so. And by creating a pot trust, you aren't setting them up for success. You may be adding fuel to the fire.
I would say you will have family disharmony. If you don't treat them equally, they're not going to get along. I've seen children fight over very small sums of money whenever it was put at issue.
Can I throw some facts to you guys that are a little bit different than the potential for somebody having a premonition that his ex-wife is going to leave his sons a lot of money, which he doesn't even know.
Right.
That's really something that's nobody should be making their estate plan based upon facts that are purely made up
Beyond their control.
and beyond their control. But let's take the situation, which often comes up similar to this particular question that this dad brought up, is what happens when I have children who have different personal wealth? Let's use the example, which is often brought up. I have three children. One's a teacher and doesn't make a lot of money. One's a doctor and is very comfortable. And one is a private equity venture capitalist who has untold sums of money. The parents don't know how much money he has. It's just remarkable sums of money. How do you divide your estate plan in that situation? What would you do, Danielle, if you had that situation?
I would still leave it equally and one, rely on my children to disclaim if they really didn't need the money. I've also seen some families solve that problem by saying, okay, I am going to skip over the ultra wealthy child, but I'm not going to leave their share to my other children. I'm going to leave their share to my grandchildren, to the children of the ultra wealthy child. And that way, they're still benefiting each line of the family equally, but not necessarily enriching the person who doesn't need the money.
In your plan, you would leave it upon the child who is in private equity, who has untold wealth, to disclaim all or part of his share. So that share goes to the teacher and to the doctor civilly. How does that work when they disclaim it?
With a disclaimer, the beneficiary cannot have taken possession of the inheritance, and instead they have 9 months to notify
9 months from when?
from the date of death to notify typically the executor of the estate or whoever is in charge of the funds that they don't want it. And it's really a written piece of paper. You probably cite the state's disclaimer statute. Every state has one saying, I disclaim my right to this inheritance. And then you are treated as predeceasing decedent. So in this example, if the disclaimant had children and the inheritance was left to them on a per stirpital basis, meaning if the beneficiary dies, it goes to their heirs, then it would pass to the grandchildren. It may not pass to the other siblings.
I see.
But the grandchildren could also disclaim and then potentially could end up with the siblings, or it just ends up with the grandchildren, which isn't that terrible of a result. And the examples I'm describing are really if you're leaving assets outright to people, which we all know we prefer to use trusts. The trust can also just hold the inheritance for that wealthy child and never make distributions to the wealthy child. So even though you've left them the money, it's not really being used and it's being accumulated for the benefit of future generation of the family.
So in that scenario, Danielle, if the wealthy child didn't use the money and it was held in trust, would the money then be for the benefit down the bloodline for the lineal descendants of that wealthy child?
That's typical, but and the trust can say whatever the client wants. So that if the client knows that they have a wealthy child, they could say that if the wealthy child disclaims his or her share goes to the siblings, it doesn't have to go to the children of the wealthy child. It's really customizable. But yeah, that's one solution. I think we talked about again the pot trust scenario. I just think it creates a mess. I'm not a fan of it. I have clients who insist upon it, but to me, it makes trustee decision making more difficult than it already is.
A pot trust, if as I understand it, is instead of dividing up the estate into three equal shares and setting up three trust shares, you would have one trust pot that has everybody as a beneficiary, and then it would be up to the trustee to decide who gets the money, as opposed to the deceased parents providing for it in his will.
Yeah. So if we had, let's say, $3 million and three children, setting up separate shares would mean that each child would get $1 million into his or her share. And what the trustee does with that share does not at all impact the other children's trust shares. With a pot trust, all 3 million would go into one account for simplicity's sake, by way of example, and all three children would share in that 3 million. So if one child had extraordinary educational expenses because they were going to medical school and so on, and they needed hundreds of thousands of dollars for their educational expenses, the trustee could make that distribution and pay those expenses, but it would almost be to the detriment of the other trust beneficiaries because there's only one pool of money.
Max, so if you had a client who came to you and she said, I have really three kind of assets. I have a house at the Jersey Shore, I have a house that I live in Pennsylvania, and I have my bank accounts, and I want to give one house to one child, another house to another child, and my bank accounts to the third child. What would you tell that person to do?
I would discourage that approach. Again, I like the approach of three equal shares because the brokerage account is likely to fluctuate in value, and both homes will fluctuate in value. And although the intent is there because maybe one child needs the money and another child would like the house and the third child would want the other house, I think that if you left it in three equal shares and once
So all assets, they get a one-third interest in all three assets.
that's correct. But I think that what will likely happen then is the executor or executrix will look at the assets, marshal the assets, and the children are going to need to decide do they want money or they want the house. And if they want the house, then the one child's going to buy out the other two children to get the house based off of an appraisal of the house. And the same with the cash. Yeah, cash is easier to split three ways, but the homes aren't. But I think that allows the children then later to see the overall value and make a determination. Do they want the home or would they like all the assets to be sold so that they can get money?
Good point. You could make all the houses could be sold and they would all just split the cash.
And that way, the decedent doesn't have to worry about did they leave three equal shares, which is inevitable, not going to be possible if we're talking about real estate in different locations as well as a brokerage account.
And that kind of goes into another topic for a different day, but leaving a vacation home to multiple beneficiaries is always ends up being a disaster, because inevitably one beneficiary uses it more than the other, but they're all sharing in carrying costs, and it inevitably leads to conflict. This way, everything is sold, the house is sold. You want a beach house? Go buy a beach house with your
Or you
share.
could buy the beach
Or
house.
buy the beach house from your siblings.
From your
Right.
siblings, yeah.
But that way you're not leaving a fight for the family, because that's really what all of these examples boil down to, is how can you reduce friction among the beneficiaries after you're gone.
So, Max, what you always tell me is you can't make a mistake by treating them all equally. That sounds like a pretty good theme.
That's the safest approach. And it's also, I think the parents or the decedent needs to take some ownership of resolving that issue. With the pot trust suggestion, I think that you're punting that fight to the trustee, and the trustee might not even understand what they're going to be involved in. And I do think it's going to lead to disharmony among the three children. So the three equal shares is the safest way to preserve family harmony. One question for you, Danielle. You had mentioned that we prefer the act be distributed or held in trust for the children or grandchildren and not distributed outright. Can you explain why?
Well, that really does a lot of things for the family. One, it protects the assets from the claims of the beneficiaries, creditors, divorcing spouses, plaintiffs, anyone you can think of. The assets are protected as long as the trust is in place for the beneficiary's lifetime. It also guarantees that the assets are going to go to whomever the parent wants them to go to after the original beneficiary is deceased. So if parent creates a trust for the benefit of children, and then it says that when my kids pass away, the trust assets continue for my grandchildren and great grandchildren and so on, the beneficiaries, other than disclaiming their rights in the trust, they can't really do a whole lot to change the provisions of that and change who the beneficiaries of the trust are.
So that's preserving the assets for grandchildren. And if one of the children don't have any grandchildren, they wouldn't leave it to their partner. It would go to the other children. So you're really benefiting your children entirely with your estate, which is what you should be allowed to do with your estate as you wish.
Absolutely.
So it enables the parents to ensure their wealth is transferred down their bloodline. I will say a planning point that we've mentioned in prior podcasts is that all individuals should look at their estate plan at least every 5 years. And this comes up especially in the stepchildren context. When they made the plan, they might have decided they don't want any money to go to the stepchild. And 5 years later, they might have changed their mind. And we've seen that before as well, where it wasn't 5 years, it was 15 years later. And then provisions were made to change the estate plan to include the stepchild as the parent got to know the stepchild better. So again, planning point, look at your documents every 5 years, talk to your counsel, and make sure that they actually reflect your then current wishes.
These are all very heavy topics that require a considerable amount of discretion and decision making. What we try to add for people, I guess, is our experience in dealing with different couples and seeing how assets are used after people pass along, which our clients won't see because we see this over and over again every single day. So we have some experience in how to formulate an estate plan. This has been a great topic, and we'll have to come up with another topic for our next podcast. What do you think?
Sounds like we have a couple ideas that are brewing.
Very good. Yes, I have at least one, but I'll save it for the next.
Okay, great.